Hello, and welcome to this edition of Nelson Mullins Education Law webinar series. Sorry for the short delay. We were having some technical difficulties. This is our second coronavirus-related webinar related to the legal needs of education institutions. And today we're going to focus on to pay or not to pay. Thank you for joining us. My name is Dan Cohen, and I'm a partner on Nelson Mullins Education Law team. Nelson Mullins is an Am Law 100 firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of education institutions, including in the areas of labor and employment, healthcare and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues affecting education institutions like student and faculty discipline, sexual misconduct, and athletics. Each month, we will host a free webinar addressing legal topics across these areas and sometimes more frequently as issues arise as they have over the last few weeks. Please feel free to contact any one of our education lawyers if you have any questions about our current or past or future webinars, or if there's any other legal issue affecting education institutions with which we can help you. Today, Suzann Wilcox and Cheryl Shaw are going to focus on contracts in the COVID-19 era. Coronavirus cancellations and disruptions are now an unfortunate fact of life for private and public colleges, universities, and K-12 schools. Managing issues regarding student fees, vendors, and contracts is an essential part of navigating the new COVID-19 environment. So today, this webinar will focus on evaluating contracts for cancellation or postponement, liability or recovery following cancellation or postponement, including for notable events like athletic events, student and staff travel, and student tuition and fees. We'll talk about developing internal processes for triaging contracts, negotiating with vendors, utilizing force majeure provisions, and finally, contract provisions that you may want to keep in mind for the future. Our presenters today are Cheryl Shaw and Suzann Wilcox. Cheryl is a transactional attorney with an LLM in taxation. She practices in both the public and private sectors, and she provides educational clients with advice in a broad range of transactions, including contract, real estate, construction, finance, SPLOST, procurement, tax, and E-rate matters. Suzann Wilcox has been providing legal services to a variety of educational institutions for the past 2 decades. Suzann focuses on policy and process development, legal training for staff at all levels, board and superintendent advisement, day-to-day issues impacting schools and students, and technology and privacy concerns. As one of the partners on our team, Suzann works hard to get clients to a place of yes in a legally compliant fashion. So with that introduction, I will now turn it over to Cheryl and Suzann.
Good morning, everyone. So sorry for the slight delay. This is Suzann Wilcox, and we're on the line. Like you all, we are all working separately and remotely, and that's have some challenges. So I just want to thank you for taking time out of your busy day and the craziness that is our world, and just spending a little time with us today as we talk about this very important topic. And for some of you, honestly, you may not even really know the scope of what you're going to be dealing with, but maybe you had enough of an inkling just to log in with us today. Thanks so much for doing that. And we know that this situation is evolving. And you know what? You may not need this information right this second, but guarantee you, if you're working with an educational institution, college, university, school, you are going to need this information. So we would be pleased to help you kind of shepherd you down this path today, and just welcome to our journey. Cheryl is on the line as well, and she's going to be speaking up as well. And I just want to Cheryl's going to do the bulk of the talking today. I'll be dipping in and out as well. But I just want to go ahead and give a personal recommendation for Cheryl, because I always tell people if I ever win the lottery, Cheryl's going to be my attorney. So when a lawyer says that about another lawyer, you know that this is good stuff. So please really enjoy her presentation today. She's just going to do a great job. Just a little more about us. Dan has shared with you who we are. There's a link here to our website. We actually have our insights and legal updates are there, including our other webinars. You are welcome to join and listen to those. If you click on that link, you actually have to scroll down a little bit. There's a little part, it looks almost like a necklace, and there's a part of it that says insights. And when you click on that, that gives you our legal updates. And just feel free to come back there and check in as we see things that are interesting or exciting. We're posting them there. Like, for instance, there was an E-rate FCC ruling that would be a very big importance to some of you all that are taking E-rate funds. The gifting rules have been sort of softened for the time being. So if you're interested in that and you are as scared of E-rate as most people are, feel free to go and take a look at that. Our team is a team of education attorneys. We actually have about 800 attorneys in our firm, but our team is focused only on education. And we have some great clients that we learn from, and we just love what we do. So want to say thank you for all your leadership and hard work. I bet you haven't slept much in the last couple of weeks or 3 weeks, and we know what that's like. We're right there with you. So please feel free to, just take a minute, take a deep breath, and learn a little bit with us today. Of course, as lawyers, we have to give you the fine print, right? This little webinar is not meant to be legal advice. And of course, and we'll be talking to you more about that, but honestly, we are just trying to figure out as we go along, and each one is going to be different. This situation is changing daily, and as we say in the South, pigs could be talking tomorrow. So if in fact that is happening, stay tuned here, and we'll try to do our best to make sure that you all are able to really get the full benefit of what we're talking about here. Well, this is a very interesting time because almost every contract as a school administrator or college or university administrator could be impacted here. So we have things like travel contracts where you have travel abroad, or maybe you have field trips if you're in the K-12 space. If you are in a college, university, or even if you're in a K-12 space, you've got sports events, you've got sponsorships for your sports events, proms or formals, student events of all kinds where you have to rent facilities, or maybe people are renting facilities from you. You've got stadium rentals, which are hugely lucrative and hugely expensive. You've got graduation venues, healthcare. If you're in the university space, maybe you have some negotiated healthcare arrangements. If you're in the K-12 space, maybe you have nurses or other folks that are able to serve your students with special needs. You've got housing, obviously that's huge, nutrition agreements, whether that be for your cafeteria program, your student dining program, or if you're talking about in a K-12 space, your cafeteria is maybe outsourced. So really you have all kinds of things. And I bet if you're like us, you're just starting to scratch the surface on what is important in this type of situation. So we're going to talk about some generally applicable information that may be helpful for you in these various contracts. And it's a lot, we know. And we also know that there is no one size fits all. I will tell you that we understand that you would love for us to say, okay, here is the silver bullet. This is all you have to do. And if you do this, then all of your contract issues will go away and everything will be fine. But unfortunately, there isn't anything like that. Your contracts are as unique as your student population, and we know it's very diverse, and you've got contracts all over the place. And so, unfortunately, each contract is going to have its own set of facts and circumstances and provisions. There is no one size fits all. But what we're going to give you today is a way to sort of tackle it, break it down, things to think about, and get you on your way at least to starting to analyze these and figure out what's the best plan of action for our folks. The first thing you want to do is gather up all of your documents. You want to make sure that you have every piece of a puzzle. And I'm going to turn it over to Cheryl to sort of talk about what gathering up all the documents will look like. I think she's on the line. Cheryl, can you hear us?
Yeah, I can. I'm concerned that our attendees may not be able to hear. A couple have emailed me and said they can't hear us, but I'm going to proceed just in case, and so that I know our session is being recorded, so if for any reason people cannot hear us, they can log in later and listen to the recording, okay?
Yes, and I hope that that is not true, but if that is true for some reason, and some of you all are joining us after the fact, please feel free to email us. We're happy to answer any questions that you might have. If you are able to hear us and you want to chat us any questions, we're happy to try to answer those. But for some reason, if that doesn't work, then we will just go ahead and send this all out as a recording to folks, a link to it. So I hope that's not the case, but If it is, I apologize if you got confused or something went wrong on our end. So we'll turn it over to Cheryl, and then we'll be sure to get this to you.
All right. So good morning, everyone. Thanks again for joining our seminar here today. You know, the very first step in a contract analysis is to actually get and read the contract. And while that sounds straightforward enough, it means really you have to gather all of the documents which make up the agreement. Some contracts incorporate other agreements in by reference, and those incorporated agreements are part of your contract and may impact your obligations. You may have policies that are publicly made and that impact your contract. So in short, it's very important to make sure that you gather and review every single document that makes up your agreement. Secondly, you need to determine who sponsored the contract, who is on the hook. Is it, who's the contracting party? Is it actually the educational institution? Is it a booster club or PTA? Is it an athletic association? So determine who's the contracting party. You know, your position on a contract is going to differ between whether you're trying to enforce the contract or get out of the contract, right? In some contracts, you're going to want to enforce, and some contracts you're going to want to try to get out of. Either way, one of the first questions you need to determine is whether or not the contract allows either party to cancel without cause or penalty. Sometimes there will be a cause or a penalty built in, even if you cancel for no cause. So that's important to ascertain. But if you're lucky enough that a contract has a cancellation without cause or penalty, and you want to get out of the contract, then you need to determine what notice you are required in order to cancel the contract. For example, the contracts will typically say notices under this contract must be sent in by this manner: certified mail, electronic mail, overnight mail, addressed to a specific person. If you fail to follow the notice requirements, then your cancellation effort may fail too. Next slide, Suzann.
Yeah, absolutely. And I think that's a good point, is that sometimes you're the windshield and sometimes you're the bug, right? So you're probably going to be on both sides of this issue. And that is one of the big things we see that some of our clients do, is they don't read the notice for termination. And so, and sometimes that can be complicated. So be sure to get advice if you're not sure how to cancel it appropriately. And if you need any assistance with that, we're happy to help.
Okay. A good question to ask is whether there's any insurance that covers the contract cancellation. I mean, these can be trip cancellation insurance coverages, student renters insurance, tuition refund insurance, and even vendor business interruption insurance. If you have a contract with a vendor and the contract has to be canceled or terminated unexpectedly, the vendor may very well have insurance which actually pays the vendor under that policy. We're going to cover later and more in detail whether or not the contract contains a force majeure provision, whether the contract has special provisions that may apply in your situation, whether the contract involves special funding like federal funding or grant money, whether has the governing body that disperses those funds granted any flexibility or guidance on how the contract is to be handled due to COVID-19. The governing law provision in a contract is going to impact your obligation. Which state law applies? Sometimes with travel contracts, we even have international law as the governing law, and that can complicate things. Where and how are disputes going to be resolved if you can't, if a dispute arises on the cancellation of the contract? Do you have to go to court? Which court? Or have you committed to arbitration or mediation? And are there any other protections or claims available under that governing law which will impact your contract? So again, typically your position under the contract is going to differ depending on whether you want to enforce it or get out of it. Whether you're trying to enforce or get out of it, you're going to need to know whether or not your contract has, again, that simple cancellation without cause remedy, or if it lacks the cancellation without cause remedy, then you're going to want to know whether it has a force majeure provision. A force majeure provision in a contract is a provision that excuses a party from not performing its contractual obligation because those obligations become impossible to perform due to an out of the ordinary, unusual, significant event that the parties could not have anticipated or controlled. Now, this clause typically will contain a list of events that the contracting parties agree qualify as a force majeure event, but sometimes state law sets the requirements. So it's just, you need to know that these force majeure provisions and enforcements differ from state to state. They also require...
Oh, sorry, Cheryl. Got excited about what you were saying. Go ahead.
No, I was going to say they also require other things like, is mitigation possible? So, you need to, even though your contract contains or includes a force majeure provision, you need to think about whether there's any way to mitigate, to make even, to mitigate the situation that you're under.
That's right. And we know that this is a fancy phrase. It really just means superior control in French. And you've seen this provision if you've ever read a contract and you're not used to reading contracts, or maybe in your own personal life you've seen it. It basically is, if anything, pestilence and the plague and all sorts of things. But it's weird. You never think about it actually coming into play. But we're in a situation now where these provisions are coming to the forefront of how contracts are being construed. So it's really a fascinating time in the law. I know it's not a fascinating time in your world every day, or maybe it is fascinating, but in a horror movie kind of way. But it is kind of unusual that these would be so widely applicable. So we're really going to focus a lot on them today.
So, the burning question is whether COVID-19 is a force majeure event that either lets the school and institution out of the contract or lets the vendor out of the contract, or the provider under a contract that the school or institution wants to enforce. So the answer is maybe COVID-19 is a majeure event and maybe it's not. You have to look at the terms. First of all, is there even a force majeure clause contained in your contract? Secondly, if it is included, then what events are listed in the clause as an event in your contract? Does it include just things like hurricanes, tornadoes, earthquakes? Or, does it actually refer to a pandemic, epidemic, serious illness, plague, disease, or outbreak? Even if the contract says that a pandemic, disease, illness, outbreak, etc. constitutes a force majeure event, which would potentially exclude the party's performance or excuse their performance, does it address how that determination is made? Now, we all know the World Health Organization officially declared COVID-19 as a pandemic on March 11th. So that could qualify, right? That could say, hey, a pandemic exists. But is WHO the entity that must make that declaration under the contract? Or does the declaration have to be made by the governor of the state whose law governs, by the CDC, who has not, while the CDC has posted the WHO's determination on its webpage, the CDC hasn't made an official determination or declaration of a pandemic. So if your institution is trying to get out of the contract, you'll likely push the position that it doesn't matter who made the declaration. A pandemic's a pandemic and it's been declared. If you're trying to enforce the contract, then you're going to split these hairs and you may go to some of these other alternative arguments. Similarly, does your force majeure clause in the contract refer to civil, emergency, national emergency, or government acts? The federal government declared a national emergency on March 13th, but the reactions and responses by state and local governments have varied widely and are fluid and changing every day. For example, some states have issued full-on shelter-in-place orders, while others have only imposed curfews or imposed partial shutdowns. Government orders that have required, vendors, businesses, schools to shut down, such as a shelter-in-place, are going to strengthen these force majeure arguments. And while government guidance that has only led to voluntary closings, nightly curfews or partial shutdowns are going to be less certain, arguments are going to be able to be made both ways. It is very important to know which governing law governs over your contract because, again, the law on these force majeure provisions differs from state to state. For example, under New York law, force majeure provisions are interpreted very narrowly, and only the events which are specifically listed in your clause will excuse performance. In Delaware, in contrast, the provisions are construed according to their plain meaning. So it's important to, determine which law applies. We also need to know whether other contract provisions impact the force majeure clause. For example, some contracts will contain a built-in remedy like, there's no refund regardless of, the reason for cancellation or early termination if the contract is 75% performed. Or X% of your deposit is non-refundable regardless of the reason of the contract termination. We see these in, for example, in like prom and graduation venue contracts. They'll say X part of the payment is due on blank day and X is due on or after the event. The day before, the day after, we'll settle up. So with these, you may have a force majeure provision that says you can cancel the contract in the event of an epidemic or pandemic, but it may not address whether or not the, quote, non-refundable, end quote, deposit is actually refundable under that instance. A central question is whether performance is truly impossible. For that force majeure provision to apply, performance must be impossible. So, for example, has your local jurisdiction restricted the number of people who can gather at athletic or other public events? If the event is scheduled to occur during that time period in which the restriction applies, then performance may be impossible. If, however, your institution is physically closed but can continue to provide instructions to students via remote learning or consortium arrangements, then performance is not impossible. A student may not like having to do online classes. A student may say, hey, that's not what I signed up for. I signed up for a bricks and mortar program, and that's what I want. Therefore, you've breached the contract. But you haven't, because performance is still possible. The force majeure provision may not apply, especially given the Department of Education's recent guidance that temporarily expands these remote learning flexibility options due to COVID-19. Understand that impossibility of performance can be asserted even if the contract lacks a force majeure clause, okay? So impossibility of performance is in and of itself a separate legal defense that can be raised by either of the contracting party. The question is whether the performance of the party's obligations is objectively impossible. And this includes legal impossibility. So where performance becomes illegal, like the mandated school closures, shelter-at-home orders, prohibition of gathering at sporting events, restriction on the number of people that may gather. The problem we have here is that differing restrictions among jurisdictions may impact whether the performance is possible or not. For example, again, a performance may be possible in a partial shutdown, but not a total shutdown. Additionally, we have inconsistent prohibitions have been imposed. For example, in some places, like in, some places only 10 people are allowed to gather. In others, 50 are allowed to gather. So, for example, in Atlanta, the mayor has prohibited congregations of greater than 10 people, but not the governor. So conceivably, UGA could host something in Athens that Georgia Tech couldn't host in Atlanta. So, this gives you an insight into why these, contract issues are so customized and personal to the contract and the contracting parties. Some states have actually codified the impossibility of performance contract defense in their statutes and listed specific criteria that must be met for the defense to apply. But other states have just used general criteria, for example, saying, oh, this defense applies, but only for acts of God. But then acts of God aren't specifically defined. You have to look to the case law to see if any acts of God have occurred before that are similar to those that we are experiencing now.
And I think it's really interesting. You see the layers here of how complicated it can be. We're used to digging these out, but if you're not in a situation where you're used to pulling apart these layers, this can seem kind of overwhelming. That's okay. We're definitely not trying to make you lawyers. We're trying to give you some perspective on things to think about. And certainly some cautionary tales for the future, which we'll talk about later. But one of the things that we are always careful about when we have the ability to be, is to not agree to other states' choice of law. So if you're in Georgia, having Georgia law cover your contract, or whatever state you're in, having that law cover your contract is ideal, because I think that can add another layer of confusion here. Well, it's impossible here, but our contract is governed by Delaware law. What's going on in Delaware, right? So that, to me, just makes it even more complicated. Of course, we're used to this type of thing. I understand if you're not, but it's just a little bit mind-bending when you start digging it apart.
Absolutely, absolutely. And then there are also business considerations that you need to take into consideration. For example, again, does the student, for example, have rental insurance that may cover room and board or loss of use due to force majeure or public emergency? Oftentimes those renter insurance only covers physical damage to the student's property, but recently they have, the insurance industry has allowed endorsements which include loss of access. Now, I don't know, maybe the student purchased rental insurance and they didn't include that endorsement, but maybe they did. Sometimes the parents of the students, their homeowner's insurance may include a clause. Again, it may only refer to physical damage of the student, but it could possibly refer to or cover loss of access due to a public emergency. You don't know until you ask. Similarly, vendor, as we discussed before.
Okay, Dan, I just...
Here.
Similarly, the a vendor may have business interruption insurance that covers the losses, due to the cancellation of the contract. Business interruption insurance, may have its own force majeure provisions that have to be separately examined. It is important to know or to ask, were the parents and students informed of or offered the opportunity to purchase insurance coverage? Was a waiver signed? This is important not only with trip events for, travel abroad programs and things like that, but even it could be when students sign the dorm contracts, making them aware that rental insurance is potentially available and letting them waive whether or not they're purchasing it or not. So let's talk about some examples, of how COVID-19 has currently impacted contracts and how we might examine those impacts and handle those contracts. So one of the big issues we know are college dormitory contracts and school closures. Due to school closures, students have been moved out of their dormitory rooms. So what obligation does the institution have to refund money paid for, for room and board when this institution closes the dormitories before the end of the semester and requires the student to move out, under COVID-19. Well, room and board contracts are just like any other contract. They have to be specifically reviewed. The institution's obligations are going to turn on the specific terms of the contract. The contract may have or may lack a force majeure provision. It may have a cancellation clause that is very favorable to the institution. The contract may state that housing payments are non-refundable beyond a certain point or beyond a certain amount. Now, if the contract doesn't have terms that are favorable to the institution, then note that the students could potentially raise constructive eviction claims. I paid for it, the contract didn't allow you to evict me, and I've been evicted. I will add that the Department of Education did issue guidance last week instructing that if the institution decides to refund the room and board payments to the students, then the institution is not required to make changes to the student's Title IV award. So I think that that's helpful. What about a study abroad student whose program has canceled? This might be a situation where the student is recalled from the travel abroad program, but now it's too late in the semester for that student to enroll in other classes offered by the home campus. Is the student due a refund? Is performance impossible in this situation? Well, pursuant to the recently issued guidance by the United States Department of Education, the institution can offer distance learning programs for these students. The institution can enter into temporary consortium agreements with other institutions so that the students can complete their courses at other institutions but be awarded credit by their home institutions. Or the students can take a leave of absence. If a leave of absence is taken, the institution retains any Title IV funds to apply when the student continues enrollment. However, if the student withdraws or does not return to the program within 180 days, then the institution must return the Title IV funds using the return of Title IV funds calculations based on the date on which the withdrawal occurred or the leave of absence began. So this is a really good example of how newly issued COVID-19 guidance impacts the contract. A similar situation is the student federal work funds and work requirements. The same guidance, what if we have a situation where the student is earning federal work funds for certain work the student is supposed to perform, but due to the school closures or employer closures or the student being quarantined, for example, the student can no longer perform that work. The guidance that has been issued says that if the institution is continuing to pay other employees, like faculty and staff, then the institution should continue to pay the students their federal work funds, even though they're not performing. What about sports sponsorships and partnership contracts? These contracts are especially tricky because of the value and the goodwill involved. For contracts that sponsor or partner, like on apparel or other products, like we're going to give you X amount of clothing and product supply, provided that you wear these and your students can only wear these things or do these things. It's important to read and understand what the institution or school promised to do and whether performance is really impossible. Maybe it's not. In these types of contracts, you may not have promised to play any games, or maybe the promise is as simple as we will only use and wear this apparel or these products. On sponsorships related to sports events, however, we've got a different scenario. The first step in those contracts is to determine if the contract includes any kind of built-in remedy, like games not played or an unavailable benefits provision, which mandates the party agree to substitute or to replace benefits of equivalent value, and whether that's even possible, given the broad cancellation. You may not be able to grant a substitute gain, right, under these times. But generally, these contracts are going to take a lot of thinking outside of the box, and rather than just sheer contract interpretation. You can do things like, consider trying to negotiate a sponsorship extension and doubling up on next year's offerings, and hopefully we're in a better place. Rather than refunding the sponsor's funds or canceling the sponsor's funding that's going to be provided on the contract, can you find a win-win situation? Can you negotiate a longer-term agreement that benefits both parties, that keeps your current funding obligation, maybe extend the contract with more benefits for the sponsor, give them a longer term, and even potentially add additional funding by the sponsor? Think about how, pitching certain things like the possibility of media or other community communication, which tout the sponsor's support for the institution during this unprecedented time of need. How much value does that carry? Is that something that the sponsor may lock into? Hey, yes, we can't play these games, but here is what we can offer you. Here's how we can, try to create or recapture the value that you were going to gain, from those events. What you're trying to do is
sorry, I didn't mean to interrupt you, Cheryl.
Go ahead.
I get excited when you start talking about these things. I get excited. So, what I think is really special about our team and what we do here is we are usually a seat at that table. We'll get together 3-4 people that are involved in a contract or putting together a facility experience or some sort of athletic experience, and we'll sit at the table with our clients and say, okay, let's spitball, let's come up with some ideas. And Cheryl is particularly creative like that, but we have lots of attorneys in our teams that do that. And it's amazing when you get those little thought groups together, what you can come up with. And she's given you some great golden nuggets here, but we're very happy to sit at the table with our clients and just kind of figure out a win-win solution. And in some of these, that's going to be your best option. We'll talk a little bit more about that later. But yeah, I think that's one of the special things that we're able to offer when you're working with attorneys who are education focused and we're part of your team. So I think it's important to have somebody at the table with that legal experience when you're having these conversations.
Yeah, and I would add too that, because we represent numerous education institutions, both at the K through 12 and the college and university level, we have the benefit of shared peer collaboration. So, we can, sometimes you can coordinate a roundtable where folks share ideas, and that is it's just a nice think tank to have. But basically, under our sports sponsorship and partnership contracts, we're trying to reach a resolution, to cut a deal, to negotiate a better one, to do something to bring that to a win-win for both parties. Similarly, like and a lot of these sports events have travel, arrangements that may have been prepaid. The question there is, if we don't have cancellation rights, we don't have cancellation insurance, then, can we negotiate? And also, we all know he who holds the funds has the most leverage, because if you've prepaid those travel, transportation, and hotel costs, are you going to try to sue to get that money back if the holder of the fund says, nah, I'm just keeping it, I don't care what your cancellation clause says? So a better approach may be to try to negotiate an application of those funds to next year's travel with a guarantee to use that same hotel, or transportation provider for a longer period of time. Suzann, do you want to talk about the examples involving other situations, maybe the nursing contractors for K through 12 schools?
Absolutely. I'll be happy to. So we know if you're providing special needs services for our fragile population or students who require nursing services on a regular basis, or even if you're running a student health services arm of your university or college, we know that a lot of times those are contracted employees. They're not necessarily employees of the university or of the school. You may also have, if you're in the K-12 setting, occupational therapists, physical therapists, speech therapists, folks that do those related services for students. But the students aren't there anymore, right? So whether your clinic is shut down because your students are off campus, or because your students are getting services online for their education right now because they're in the K-12 setting or even the university setting, the students aren't accessible. One thing that we're hearing some folks doing, especially with the K-12, because you know that if you are continuing to provide those educational online services, that you're still required to provide those students a free and appropriate public education, your disabled students, or FAPE, as we like to call it. And if you're in the university setting, your eyes might be glazing over. Just bear with me for a second here. This will have some applicability potentially to you as well. But for those folks in the K-12 setting, you may still, if this shutdown continues as long as it might, you may want to consider pushing some of those services in the home, looking into virtual services for those students, lots of different ways to serve those students. So it may be that you still want to have those nursing folks providing care. It may be something we push into the home if this keeps going long term. You may have already decided to do that. So keep that in mind. That may be something you could do with that contract to get some of the value out of that and to keep those nurses and folks working is something that you might be able to do there. So that's something unique we've seen some of our clients considering is, you know, we can't do it on campus, but maybe we can do teleservices. So let's say you have therapists that serve your university population or doctors that serve your university population. It may be that you still want to offer some of those services via teleservice. And that's sort of beyond the scope of what we're talking about today, but it's definitely a viable business model and could be something that you could get some value out of. So this is the time to think creatively. Don't take anything off the table. You know, it's possible that you can work it out. And Cheryl and I always laugh and say, you know, they don't hire us to tell them no, they hire us to tell them how to get there. And that should be your goal as well, is to find out, how do we get there? If we want to do it, if you have this great idea, how do you get there in a legally compliant fashion? You'd be surprised what you can work out and finagle when you have the right attitude about it. So that's just a word of encouragement about some of these contracts and something to think about. Start thinking creatively.
I agree with that, Suzann. And, you know, it's very important to, you know, not to just simply enforce the contract on the face of its terms, but think about the goodwill and the business side when you are figuring out what approach is best in your particular situation. You know, never hurts to negotiate. You never know where you might get, even if your contract provisions are absolutely clear. You know, there's always a potential creative solution. You know, I would also recommend that folks be proactive. Okay, I mean, we know we have contracts right now which are impacted with COVID-19 and are COVID-19ing all of us, right? I mean, but what future contracts? We have contracts on the horizon. If this continues, how is this going to affect contracts that are to be performed in the fall, for example? Do we have a backup plan? What's our, you know, should we be thinking creatively now? Should we be reaching out to those vendors now on a, hey, we don't think this is going to happen, but if it does, let's go ahead and start talking about you know, remedies and plan A's and plan B's. You know, be proactive so that you're not taken aback or behind the eight ball if this COVID-19 mess continues.
That's right. And we've also recommended, and if you look on our webpage, as I said at the beginning, under the insights, there's our COVID-19 kind of general webinar that we did. One of our recommendations was start thinking about your reopening now. Start thinking about what services, how are you going to reopen, when, how, are we going to do it staggered, rolling? I mean, it may be that you don't reopen to the fall for some of you colleges, universities, or to the summer session, But just start thinking now about what is that going to look like, because it's going to be tricky. And if you're not planning for it now, you're going to be behind the 8 ball for sure, as Cheryl said. And the other thing you might want to think about, and we've had this come up a few times, is maybe you have a very specialized vendor. Let's take, I don't know, speech therapists perhaps, or something along those lines that are in scarce supply, or maybe nursing contracts where nurses are hard to come by in your area. And you are concerned that if you, like the goodwill issue, that if you don't keep them on the rolls, that they're either the company is going to dissolve, or the nurses are all going to be gone, or the vendor will disappear and not come back. So you really do have to keep that in mind when you're deciding whether or not you're going to pay some of these folks. Now, I'm not saying go ahead and just pay all your vendors because you don't want them to go away. But if there are some very key players and folks you can't do without, that's something to really think about. And maybe that doesn't mean that you're going to pay them, but maybe that means you're going to put special attention on keeping them sort of happy and waiting for you when you're ready to start services back. You have to be careful, what you do for one vendor, you don't want to do for all vendors. And I understand that slippery slope, but there may be some special exceptions that you really have to think about. And those are business decisions, but we are very used to the world that you live in, and we're happy to talk through those business decisions with you, because you have to be strategic in this environment. You don't want to be the only school or university or college that doesn't have a nursing staff set up when you get back up and running, and that sort of thing. So just remember to be proactive, as Cheryl said. And I'll just kind of walk you through some of the lessons we've learned, and Cheryl will chime in as we talk. One thing we're finding people are scrambling to do now, if they don't have a well-organized contracting department, is they don't have their agreements. They don't even know what agreements that they have. And that gets tricky, because if your folks are home, which most people probably are at this point, you may not have access to those paper files or those databases, and you don't really know what agreements you have. So I think one way that folks are doing that is they're putting all calls out to their staff, and they're getting somebody in charge of hunting those down and pulling the full agreement. But make sure in the future that you're compiling those agreements. You're keeping all the agreements in one place. You're keeping signed copies. That's so huge. Sometimes clients forget to keep signed copies, but get a signed copy, put it in that file. And also with these technology agreements, if you have not really ever read one of those, there's like 17 agreements in one agreement. So also the agreements that are incorporated by reference. So you don't have to be a legal ninja, master to understand how to do that. You really just look at the agreement, and it will reference other documents. When it references another document, that's probably part of the document of the agreement. So make sure that you are putting those agreements together as well. If you send it to your attorney, like if you were to send it to us, that's the first thing we're going to look for, is to make sure we have all the attachments, all the exhibits, everything. So we're going to need that. And consider keeping those in one spot. And I'll let Cheryl kind of give you some more tips on that point.
Yeah, I think it's important, to keep an inventory of all contracts so that you have a master list that lists, the contracts, the dates of the contracts, the date of expiration, etc. We typically prepare master lists for our clients of what we get on their behalf, and it's a good business thing to do. One thing, I guess, out of all terrible circumstances, we learn and we come up with better procedures and processes, right? One takeaway from this COVID-19 issue is we have, our clients have learned they need to negotiate cancellation and remedies up front. It's better to consider, and granted, no one ever thought, I don't think anyone in their right mind had ever thought that a pandemic was going to hit. And the measures we're facing now that we would be facing, but we have now, and so it's important to negotiate cancellation issues up front and remedies. So if that force majeure clause does apply, you can craft your contract to say this is what's going to happen in that event. Think ahead about those things.
I bet your contracts will look very different in the future.
Oh, yeah, the laundry list of events. I mean, now we're going to have a page of potential force majeure events, right? But depending, but again, it bites both ways, because in some contracts you're going to want to enforce, and you don't want that force majeure cancellation to apply, and in others you want to get out of the contract, so you do want it to apply. So, that's why it's important on the business side to say, well, if it applies, here's what I would be happy with. Here's what I need to do to keep my organization alive should this crazy event occur. If there's an opportunity to offer or insurance, if there's any type of insurance coverage, it's important to make sure that you offer it or inform the the parents or the students that it's available, and maybe have a waiver signed so that you will reduce your liability down the line, if something unforeseen occurs. Take advantage of any kind of new insurance endorsements which cover events, these force majeure provisions as they become available. And always, always, always ensure that your state law, if at all possible, is the governing place and the governing law for dispute resolution. You don't want to have you don't want to be in Georgia and have agreed that California laws apply and that we're going to go to California to litigate or to mediate or arbitrate any of the cancellation issues that we find ourselves faced with.
That's a great point. And that's something that is a sticking point in some contracts. And we have tricks and tips to kind of get around that or deal with that, because a lot of folks play that game of throwing in a far-flung state, one that, just surprise, happens to have much more forgiving law to whatever topic this is about for the person who drafted the contract. So that's something that we can work on, because that can be a sticking point in a lot of negotiations. It doesn't sound very exciting, but it actually can be quite an issue.
Well, I want to thank everybody for joining us today. I know that we realized that we may have had a few audio issues early on in the webinar. Suzann, I think this webinar will be available for folks who need it, who may not have caught the audio on the beginning of the slides, and to others who may be interested. And again, just know that we are happy to help you and to provide resources to you in any way that we can during this unprecedented time of COVID-19 contracting and impacts.
Absolutely. Thank you so much for taking time out of your day. If you couldn't hear us, I'm so sorry. But we're going to send you this recorded webinar, and we apologize if it created any issues for your day. I think a lot of us have been noticing while we've been working from home that technology has sort of been going haywire a bit. So we'll just roll with it, and we'll just make the best of it. And if we can assist you in any way, if you just need someone to spitball things with, you just want to drop us an email and get some thoughts on something, we are here for you. We're happy to assist. Thank you for everything that you do for students and what you're doing for your institutions. And I will say that I think when the dust settles, the real heroes in this are going to be our school folks and our healthcare workers, because you all had to jump into action in ways that people don't even understand. Although after homeschooling their kids for a few months, they might understand, or even a few days. But again, we just really appreciate you. Thank you for everything you do, and we look forward to the future and serving you if you need any assistance.